Good evening. This is John Milburn for Laws 12062, Alternative Dispute Resolution. We're into week 3 of Term 2, 2017. Tonight we're continuing on from discussions last week, which centre around the skills which are required and applied in mediation and conciliation. I'm going to share the screen and recap briefly to identify where we're at, and then continue on from there. You should hopefully now see a screen. If you could just give me a nod or a thumbs up. You can see the PowerPoint. Right, thank you very much. Excellent. All right, so last week we talked about preparing for an ADR process. And this week we're going to follow on from that in terms of some practical aspects for the preparation and application of issues for mediation. There is, as we mentioned last week, very little realistic prospect of success if you fail to prepare well. And you'll recall some of the things that we talked about that you should do in order to prepare. And bear in mind that most of the disputes simply arise as a result of mistaken, poor or accidental communication. So that being the case, we need to anticipate the opportunities, anticipate the impediments, and prepare well. So your client needs to understand the process, can attend, has authority to settle. You need to ensure that the evidence that you have is sufficient to do your case justice. Prepare drafts. Is there a mediation or conciliation statement that you've provided to the mediator or conciliator? Have you prepared an outline of your client's position and interests? And have you spoken with the other side about an agreed set of facts or legal issues? It may be that prior to the mediation or at the commencement of mediation, you and your opponent can agree on some facts, issues in dispute, and identify the issues that are to be considered by the court. Doing all of these things is likely to shorten the length of the trial, decrease the legal fees to your client, or potentially increase your prospects of successfully claiming costs if you're successful. And part of the role that you play is to prepare a risk analysis and do that with your client. We talked about some of the issues last week that you need to consider, and these are prompts that you can use when you're discussing matters with your client. I can indicate that I have now uploaded the full version of this paper onto the website. So when you're preparing your client, you need to talk about legal fees, talk about what the fees will be in the future, what are the prospects of a court making a costs order, think about the additional fees for trial if the matter doesn't settle, what else could your client do with the time and money, and are there other issues relating to reputation and costs, and then go through with your client the issues about stress that might be caused as a result of not settling the matter. So we now move on to the next issue, which relates to participating in the ADR process. So when we have a situation of dispute, there are a number of questions that you may want to ask. Some of those questions, if you're a mediator, might be asking why the matter hasn't settled so far. But you need to be sensitive to the background circumstances and ask the right questions at the right time. You can ask your client some of these questions leading up to ADR process, and it's a good opportunity for you to speak with your client about some of these issues. Why hasn't the matter settled? What would help to settle the matter? What risks do you face if the matter is not settled? And what would you like to get out of today? Knowing that that's likely to be the sort of questions that the ADR practitioner will ask will provide you with an opportunity to better prepare your client for the ADR session. So when it comes to the session itself, as far as the mediator or conciliator is concerned, they'll use a number of techniques all of which are designed to increase the prospects of a successful outcome. Early on, particularly where it's a contentious issue, an emotional issue, it's likely that the mediator will need to sponge. What I mean by that is that the mediator tries to embrace, for want of a better term, the likely emotional explosion or outbursts that we see often in a mediation session. Sponging is not counselling, it's simply absorbing the pressure. And a part of absorbing the pressure is to take it away from the other side, so that the party that is aggressive or subject to the emotional outburst is not directing that at the other party, which could mean a walkout at an early stage. So as a mediator, sponge, take that part of the emotional outburst from the beginning. It's an ongoing technique, but it's most likely to be something that you need to do at the start. As a mediator or conciliator, you need to very carefully and actively listen and acknowledge. Active listening is very important, not just for the mediator, but as a lawyer generally. The mediator is likely to ask open, exploratory, or clarifying questions or things of that nature. So be aware of that issue. The mediator is likely to summarize in order to transition. So if you need, for want of a bit of a term, a segue, a good way to do that is to summarize where we're at. And in the course of summarizing, most good mediators will highlight the points of agreement and congratulate the parties for coming this far and encourage them to continue on in that spirit of cooperation. Sometimes a mediator needs to use silence as a technique. It might seem odd, but it does work. If you find particularly there's a stalemate and one or both parties are being particularly unreasonable or unwilling to consider options, using silence as a mediator can sometimes almost force the parties to start speaking. People don't like a vacuum. They don't like that awkward silence in conversation. So by appropriately using silence, a mediator can actually encourage them, by doing nothing at all, to start speaking again and kickstart the mediation. A mediator might ask questions to reality test. By reality testing, what I mean is asking questions that encourage the people to think about the consequences of what their position is or what their interests should be, how they should be considering things. Reality testing might be asking questions that explore whether the participant has considered the cost to themselves, financially, to their family, to their business, whatever it might be. So reality testing is asking an open series of questions, typically, which invites the party to think about the consequences of not settling today. The mediator might encourage the parties to generate options and possible solutions. Now we call that brainstorming, and I'll often mention that in the mediator's opening statement, that if we get to the stage where we're not making great progress, I simply ask the parties to help me, and I ask for their cooperation, and I ask them to think about any option that we could at least consider and any solution that they could come up with, in the knowledge that in doing so, they're not giving anything away. The process is entirely confidential, but sometimes these brainstorming exercises lead to a solution. They're particularly useful if the parties come up with the option generated through this brainstorming exercise. And another technique used by mediators is to reframe. Now, reframing is different to summarising. Summarising is, as the name implies, taking the material and putting it into a condensed form. Reframing is different. It has some elements of summarising, but it's a summary and deflect situation. It's a detoxification technique. So we'll do some of those shortly. And you'll need to be aware of all of these techniques when it comes to undertaking your first assessment where you are the mediator or the conciliator. The more of these sorts of techniques that you can demonstrate for me in the short period of time available to you, the better your mediation will come across. So you do need to know these techniques, and need to be able to implement them. But to implement them on the run at the moment that it's called for means you've got to practice and be ready for it. Okay, let's talk now about reframing in a little more detail. So reframing is where you take a statement and you have a particular response with a purpose in mind. It's a skill where you capture the essence of what has been said and communicate it back to the person who said it in a detoxified form. Okay, let's look at some concrete examples. And again, these are now on the website, so you'll have them available. Hopefully you can read that. So let's detoxify. The purpose is to strip the emotive content from a statement. Here's the statement. He's always leaving things lying around. Your response as a mediator might be, so you have concerns about his lifestyle and you want him to know how his actions impact on you. You're stripping away the emotive content and you're detoxifying it. You're looking to use reframing to transition from the negative to the positive. So the purpose is to encourage that transition from negative to positive so that your response creates a possible solution. So here's a statement. He never tells me what is going on with the company's finances. You take that negative statement, we try to generate a solution from it by saying, so you would like to have direct access to the company's financial records. So you can see that you have taken out the emotive content, you've taken away the personality, you've summarized what's there, but you've sent it back in such a way as to encourage the parties to consider a resolution. Another form of reframing is transitioning to the future. And you can see that what we're looking to do in mediation is to create a mindset which is positive and future focused as opposed to negative and past focused. So the purpose here is to encourage a transition from the past to the future so that your response creates an atmosphere conducive for resolving the dispute. Here's a statement. My daughter was such a lovely girl. I don't know why she became so bitter. We want to turn that round, start to look to the future. So you love your daughter and you want a caring and mutually respected relationship with your daughter. Yes, that's what I want in the future, is the sort of response you're looking for. And you're now starting to encourage the party to think into the future. Reframing can also assist with future negotiations. You want to encourage ways to assist the negotiations in the future. You want to encourage your client or the party, depending on whether you're acting for a client or you're the mediator, to think about ways to resolve the matter into the future. So here's a statement. He can no longer work at this company. It's as simple as that. How do you face that as a mediator? You say, well, let's think about this from his perspective for a moment. Is he able to move into another industry, or can we do something to facilitate his retraining? What we're doing is we're acknowledging the statement. He can't work at that company. Fine, that's very negative, but it's not actually conducive for future negotiations. Let's summarize that statement. He's not going to work at the company, but try to encourage some resolution by putting up some consideration of alternatives to allow him to move on from the company. So the premise remains, we're just opening up opportunities by that statement. You'll hear me often talk about the benefit of encouraging parties to think about their interest, and not their position. Their interest is what is truly important to them. Their position might be something that is negative and possibly unreasonable. So in order to encourage people to move towards their interests, we need to emphasize what is important to them. Again, it's to maximize prospects of successfully resolving the dispute. So here's a statement. I cannot live this way with all that noise coming from my neighbour's property. I'm not sleeping. So your response, so you like living where you are and you want to maintain your lifestyle. Okay, that's really my interest. It's not so much the noise, but my interest here is to stay where I am and maintain the lifestyle. So you're trying to encourage parties to think that way. Shared approach means encouraging the parties to at least come together to share the problem. Again, you're looking to focus on interests rather than positions. Statement, he's so stubborn, he will not even think about how we can pay the school fees. Response, so it's important for you both to consider how to pay creditors. Yes, it's important for both of us to do that. What we're doing by that statement is we're encouraging the parties. What we're doing by that statement is we're encouraging the parties to focus on the problem and not to focus on each other. And we've got a common aspect then. We've got a common aim, a common ambition between the parties. And that's always important if we can do it. Now, are there any questions so far? Feel free to unmute your microphone. Use the chat facility. Otherwise, I'll continue. And if you do have questions, feel free just to interrupt, either use the chat facility or unmute your microphone and come in. So that's what I mean by reframing. So the thing about this course, what I'm talking about now, is that it's not a theoretical exercise. I'm not asking you to learn these things as an academic exercise. We're not talking much law at the moment. We'll talk more about that later in the course, but for the moment, we're talking about you being an ADR practitioner or you being a lawyer that is representing a party in ADR. There's a lot of practicalities about it. And you can't just learn about these things like reframing in isolation in a theoretical sense. You're going to have to practice it. Maybe look at these questions or these statements that are the negative statements, write them down, don't put the responses, walk away from it for a couple of days, then come back to the questions as if they're, or ask someone to read the statement, the negative statement, and see if you can respond with a good reframing response immediately. And if you can't, then work on it. Does that make sense? All right. Now we're talking about the ADR process. We're talking about what happens in practice. There is the issue of making offers. So the way that you or your client makes an offer to a party is important, and you mustn't underestimate the potential importance of making the first offer. Many parties in a mediation don't want to make the first offer. I'm not sure that that's a good strategy. In fact, I'll go so far as to say often that's a mistake. You see, by making the first offer, you help to establish the range. And also, when you're acting for a party in a mediation session, or you are the mediator, try to package the offer. What I mean by that is that you need an offer that allows the other party to negotiate in a way that's comparing apples with apples. So think about all aspects of the offer so that if it's accepted, it is a complete resolution of matters of dispute between the parties. So we need to be talking the same language and specifics when it comes to making settlement offers and dealing with settlement offers. Reassure your client. It's important that you normalize the experience for your client. Let them know that they may well find the process frustrating, but encourage them to be open and flexible. So when you go into a mediation session, if you're encouraging your client to do that, make sure that they're aware that it can be potentially pretty tough for them at that stage. I'm just going to stop the share for a moment. And again, if you have any questions, please let me know. So what we've been discussing so far this evening is what is it that will occur in a mediation session to which you should prepare, and how will the parties be expected to act, or what are the likely things that are going to crop up. When you're acting as the mediator or conciliator in the first exercise, remember your body language. There are some important things that you can do as the mediator or the conciliator during the ADR session. Positive body language is always important. So be careful about how you sit, how you posture yourself. I'll be looking for those things. If, generally speaking, if you're back in the chair and you're using negative body language, it's not conducive to a settlement. But if you're open, if your body language is open, if you're towards the front of your seat, if you're engaging with the participants, you're smiling, you're actively listening, you're acknowledging, you're sponging if there's an emotional outburst, and you're asking those exploratory, open, clarifying questions, then that's a really good start. I'll be looking for those things in the assessment. Remember the objective that we talked about in week 1, that during the ADR session, you may well want to be, as Professor Ashman from QCAT mentioned, their new best friend, both parties' new best friend. And you can do that if you're personable and you engage with them. And engaging with them means at least maintaining eye contact and listening carefully to what they say. When you're the mediator, I'll also be looking for your ability to summarise where appropriate, maybe summarise in order to transition, as we talked about, the segue. I'll be looking to see if you're impartial and fair, if you give equal time to the participants, or as best you can, equal time to the participants. I'll be looking to see if you help the parties to keep the communication going, if your interactions are fair and they're positive, and sometimes if you've used silence to good effect. But almost certainly you'll need to reframe. You'll need to use those detoxification techniques that we talked about when looking at those examples. You'll certainly need to remain attentive. It's really hard work being a good mediator. After 3 hours, you're exhausted because there's so much active listening. And the active listening, as I mentioned earlier, may mean listening for a word or a phrase that you can then use as the future focus for further discussions. So you need to remain attentive, and you need to ask questions for reality testing and encourage the parties to brainstorm and to ask appropriate questions. Now, Karen, I understand you've got a question.
Just in relation to what you were just saying about how draining it can be after 3 hours. And from what I've read, obviously mediation doesn't always conclude in one session. So in our assignment, where we've only got 25 minutes, you're not expecting us to solve the problems of the world or anything, are you?
Not at all. And in fact, I'm really pleased you asked that question because I'd forgotten to mention it. You don't get any marks, extra marks at all for resolving or having the parties resolve the dispute. In fact, you may get worse marks because if the parties work straight towards a resolution in 10 minutes, you may not have had an opportunity to showcase some of these skills. So don't be at all concerned if you reach a stage where perhaps you've identified 1 or 2 points of general agreement and indicate to the parties that given the time constraints, it might be appropriate to organise another session for the mediation, which you won't do, but at least you'll sign off that way. And try and sign it off on a positive note with some agreement to continue with the discussions. So thank you for that question, Karen. That was great. Any other questions or comments? All right. So we know now about reframing. We know if we're a lawyer going into a mediation session, what it is that we need to do to prepare the clients. But there's a little bit more I want to talk about in the context of what I call specific skills. I'll just share the screen again. Okay. So here we have a genogram. I call it a genogram. Others might call it something different. But in genealogy, the genogram, and I'm not a genealogist, so those people that are will probably say I'm pronouncing it incorrectly, but a genogram represents family relationships through the use of simple symbols. So that's kind of a genogram. Very simple. I'm going to invite you to use that technique when you're taking instructions from a client and using something that will, like that, which will assist you during the mediation session. Here's a rookie error for both mediators and lawyers that are acting for parties in a mediation. The parties know each other. They know each other's cousins, aunties, wives, co-directors, partners, employees, whatever it might be. I've mentioned before that mediation is an opportunity for the parties to own the dispute. Litigation typically is where the lawyers take over the dispute. The lawyers frame the pleadings. The lawyers are the ones up on their feet talking, and they might talk in terms of the plaintiff and the defendant, or the appellant and the respondent. They might talk in terms of Mr. and Mrs. But clients typically don't do that. If we're involved in litigation, they're not likely to talk about the other party as the respondent. They might talk about the other party as Mr. Smith, but in all likelihood, they might say Robert, meaning Robert Smith, the defendant to the proceedings. But they might have a nickname. They might not call Robert Smith Robert. They might call him Rob or Bob or Bobby. Or it might be they use their second name typically, or a nickname. Now, you've got to be on top of that, because the last thing that you want to do as a mediator is make good progress. People are starting to talk to each other, which is what you want. They're making some progress, and then you butt in and say, "Oh, I'm sorry, who's Jimmy again?" I mean, it just deflates the whole thing. And seriously, people then start to lose confidence in you. "Oh, we've been talking about Jimmy for the last 5 minutes. Oh, do you mean the plaintiff? Oh, yeah, the plaintiff." And then they try again. But by that stage, you know, the momentum's broken. And if you're the lawyer, you've got to know what these things are as well. So the point about the genogram and the taking of instructions is to make sure you know the names of the participants or the people that are likely to be involved in the dispute, either directly or by reference. You need to know their relationships, and you need to know the names by which they're actually known. So a good way to do it, and I've actually used this a lot, is using a genogram. So let's go back to the screen share, and I'm going to actually give you an exercise to do tonight. So you'll love this. Some homework to do during the live session. All right, so there's the genogram. That's a technique that I've suggested you can use while you're taking instructions. It's a simple flow chart, and it might be used to provide a list of participants, and you might be able to use it in conjunction with a chronology as well. Chronology is always very valuable tools. Be creative when you're preparing your flow chart or your relationship chart. This is one from Love Actually, showing the relationship between all the parties that were involved in that movie. I'm not sure if it was a book, it probably was, but I'm familiar only with the movie. I'm sure most of you have seen it. If you haven't, I'm sure you might like to. So that's a relationship chart. It just gives the idea of the names of the people involved. It will have some statement about their nickname. In this case, it's talking about the actors who played those particular parts, and it might have some brief statement about why they are relevant to the particular matters. Okay, so that's what we mean by a genogram, and I'll give you an exercise on that shortly. Before I finish, just a couple of specialty mediation and conciliation processes. QCAT has a hybrid hearings process. I may have mentioned this before. What it means is that in a QCAT hybrid hearing, you may have to advise clients about it. We hear the matter in the usual manner. We then write the decision, and it's usually for quick matters. Write the decision, seal the decision in an envelope, and then we go into mediation phase. So it's actually having a mediation after the hearing. The mediator will assist the parties to come to a resolution. If they do, great. If not, after a relatively short mediation, say 15 or 20 minutes, we'll go back and we'll unseal the envelope and we'll announce the order that's being made. Youth justice conferences and case conferencing justice mediations is another specialty mediation area. This is for the criminal law sphere, and it's where the parties involved in criminal proceedings, usually the complainant and the defendant, have an opportunity to involve themselves in a mediation process. Really interesting area. It's a growing area, and it's one that I'd really like you to think about. Possibly that's an exam hint. But what you need to do is think about how you can involve yourself as a mediator or conciliator in circumstances where charges have been laid and you're invited to act as the mediator between the defendant and the complainant. So in the youth justice conferencing, it might be a 16-year-old who's committed some willful damage, and it's an opportunity for the defendant to sit opposite a room in a controlled environment with the complainant, who's a 7-year-old woman, who says to the young person how much the item which was damaged actually meant in terms of sentimental value. Or it might be used in circumstances where we have a party who's charged with serious fraud, $100,000 worth of fraud, can't pay it, but participates in a mediation session, and whether there's something can be structured in that mediation agreement to enable the person who is the wrongdoer to some way make recompense to the complainant. So they're kind of specialised mediation sessions, and there are other ones such as family group meetings for child protection proceedings as well. Okay, any questions then or comments? That's all we propose to talk about for that mediation session, but I will give you the exercise that I mentioned earlier. And those of you that have got access to Moodle, I've uploaded this exercise as week 3 in the week 3 material. But now I'll just bring this session up on my other screen, if you can bear with me a moment. And it's based on what we were talking about earlier in terms of the genogram situation. All right, so we have, just bear with me a sec, we're almost there. So you'll need your paper and pen for this one. I'll share the screen. All right, so here's the practical skills exercise. It's all around the issue of the parties being encouraged to take ownership of the dispute. Lawyers do find that difficult because the lawyers want to take control. But during the ADR session, we need to understand that the plaintiff might be Mr. Smith, or might be Mrs. Smith, or it might be Jane, or it might be a nickname. So quickly, the ADR practitioner and the lawyers need to identify the names and the relationships of people involved in the dispute. One way to do that is the flowchart. So there's the genogram that we talked about before. There's the example from Love Actually. Now here's the exercise. You would think, I'm just going to put this on the one page, so just bear with me for a sec while I do that. Okay, so can you read this now? Sorry. So what I want you to do is just take 5 minutes, and I'll be quiet during that time, to read that material and construct your own little genogram. I'll then ask you some questions. So we'll give you about 5, maybe 10 at most minutes. Okay, good luck with that. How are we going? We need a bit more time? All right, how have we gone? We ready to go? All right, I'm going to stop the share now so you'll lose the info, but thank you for participating. Okay, so there we have a situation which is quite common in terms of disputes and applies at all levels, whether it's a neighbourhood dispute, a family law dispute, co-directors dispute, anything at all. So now that you've got your genogram, I'm just going to see if asking making these statements makes it easier for you to follow what's going on. So during the course of the mediation, you learn three things. Now, the first one is, and just follow there's no right or wrong answer. I just want you to follow the paths so you can see if you can understand the situation. Number one, Danny has recently started seeing Mary, but he could not bring himself to tell JB. Sue is very upset at this latest development, and she phones Donald to voice their disapproval. Were you able to follow that using the genogram? Good. Number two, in the meantime, Jack and Derek, who are kickboxing enthusiasts, decide to take action, and they encourage Tommy to confront Betty. Of course, Tommy has reservations, and Jill encourages Jack because she has mother-daughter issues. Follow that? And number three, through Cody, Ricky knows Michael. Ricky tells Michael what he heard Doris say about Donald. Okay. Now, you can understand, just going back to the statement that I made earlier, as a mediator, when people are involved in these sorts of discussions and those sorts of statements come out, the last thing that you want to do is stop the flow by asking who Sue is. Do you understand what I'm getting at? You need to be on top of that. It's your job to keep up with them. The dispute is theirs. It's not your dispute. We're not in a courtroom. We're in an ADR session. Okay, just a few general comments. We've got a little bit of time. In terms of conflict, you've read about the nature of conflict and some of the hallmarks of conflict in your textbook. The reason we tell you these things in ADR is that when you're dealing with real life situations and real people, it does pay to know some of these things. So conflict is often characterized by tension, by poor communication. It might be miscommunication, or it might be lack of communication, or lack of information rather. So if you know some of these things, if you've got some notes hidden down somewhere, you can draw out information from parties as to the nature of the conflict by trying to ask questions which identify the underlying cause. There might be some issues to do with capacity. People might have issues to do with mental health or reduced cognitive function, or there might be language difficulties. So these are all impediments to good communication. Now let's think about the way in which people act when they're in conflict. Well, a motive, we'll be ready for that because we'll be ready to sponge. You're ready for it. Sometimes people go into avoidance mode. So that's where you need to use your perhaps some brainstorming techniques, maybe silence, but you need to try to draw them out of their avoidance issues by asking open questions. There might be anger, distrust, people might fail to listen. There might be issues to do with trying to inflict pain, which means that as a mediator or conciliator, you need to be aware of that and use your techniques to avoid that pain being directed, or that intent to inflict pain being directed to the other side. Sometimes people are the opposite and they actually revel in the pain, that sort of martyr syndrome. So you need to do some reality testing there as well. There might be some other factors that come into it. Might be health or time constraints. There might be financial factors. Sometimes you draw these things out in private conference. So people may be embarrassed to say that they have a lack of experience, or they aren't coping at work, but they might be prepared to tell you that in private session. Be careful about asking those sorts of open-ended questions that do have the potential to embarrass people as well. So communication is really important. What you need to do is think about your strengths and your weaknesses, and either use those or develop them and gain confidence. One way to do that is through the reframing exercise. So as part of your exercise this week, I'd like you to think about any negative comments that you might hear on when you're watching TV, when you're at home, when you're at work, if you're just anywhere at all. If you hear negative techniques in your own mind, or statements in your own mind, think about, if I was the mediator and I heard that, how could I reframe that? How could I detoxify it, send it back with a positive message, and just make that your exercise for the week. Also, you need to be able to ask those open questions that we talked about, and active listening is really important. So do, as another part of your exercise for this week, just try and enhance your active listening techniques and your body language techniques. See if you get a good response if you do things in a certain way when speaking with people or interacting with people, as opposed to a very negative, dismissive way. If you maintain eye contact and you genuinely appear to the person that's speaking to be listening carefully to what they're saying, see what sort of reaction you get, as opposed to not maintaining eye contact and not being obviously an active listener. Now, of course, bear in mind there are some cultural issues that may come into play, particularly for Indigenous people in this regard. So you need to be aware of that as well. So try these techniques about the sorts of things that you may have to do in your mediation. Start practicing them now. Active listening, sponging, body language, reframing. And all of this is good practice for becoming a conflict coach as well. So conflict coaches are where they're not in a mediation session particularly, but they're trying to use these same sorts of techniques to assist parties in dealing with conflicts into the future. And remember, of course, that in ADR we've been talking about interests as opposed to positions, and litigation takes away the dispute from the parties, and it won't necessarily be about what's in their interest. It might be litigation about their position. So there's much greater flexibility, more room to manoeuvre in properly conducted ADR sessions. In the text, you'll read about the advantages of negotiation, and I'd encourage you to read through those. The parties, says Spencer in attribute number 4, are in the best position to assess the impact of any proposed solution. The parties own the process and they can define the terms that they choose. That's attribute number 7. And parties create their own solution and they're more committed to ensuring an agreed settlement that works. That's attribute number 2. The parties have a chance to get part of what they want in a mediation, but in a litigation it might be all or nothing. And of course, there are issues to do with timing. It's much better to resolve matters early rather than later. So we've talked about the sorts of things that you need to consider leading up to a mediation session. I hope that you accept my premise that as lawyers involving yourself in the mediation process, you're going to be in a much better position to assist the parties to resolve the matters if you take preparatory steps and you prepare. If you've spoken with your clients about the issues that are of real importance, and with your clients leading up to the mediation, you've considered options, you've considered alternatives, and of course you've tried to negotiate in good faith. So when it comes to negotiations, bear in mind the 4 models of negotiation that are outlined in your text: adversarial negotiation, integrative negotiation, distributive negotiation, and principled negotiation. So they're not specifically referred to that in practice. No one will commence negotiations by announcing to you that they intend to do so by using, say, integrative negotiation. These are things that you will need to learn, and it will become intuitive as to what you're doing and what the other side is doing as well. And in some ways, these categorizations are more theoretical than real. You don't have to commence negotiations based on one or other. But do have an understanding of the difference between those 4 models of negotiation. Adversarial is probably the closest to litigation in that there's a winner and there's a loser. That's what we often see, but it's not necessarily the best. It's not necessarily a creative way to negotiate. It's a very competitive form of negotiation. And it's not always the best way to do it. Now, the orange story, which is used to illustrate the basic problem, is this. It's from Fisher and Urey in their book. 2 sisters, they both wanted an entire orange. One solution, probably the solution that would be coming from the court, is take the orange, cut it in half, give it to both of them, close the file and walk away. But can you think of other solutions that may be better to resolve the issue for the benefit of the clients that actually meet with their interests? Does anyone know this story? The story of the orange and the 2 sisters? And the way it panned out? No? Karen does? Yummy does?
Yeah.
Yeah, so what happened? What's the story about?
I might be not very clear with that, but I think the first thing is to ask what both of them want to do with the orange.
Yep.
And from there decide how they both can achieve what they wanted with the orange. Like if one wanted juice, orange juice, and the other one, I don't think, wants to bake orange cake or something. I don't know.
Absolutely spot on. Yep, no, that's great. Thank you very much. Karen, did you want to add anything to that? Jazz? Jazz, do you want to unmute your microphone?
Sure, sorry, it's just I
All
was
right.
distracted. So I think from memory, I think one of them wanted like the flesh of the orange to eat it or something like that, and the other one wanted to have the marmalade to make the skin to make a marmalade out of.
Yeah, that's it. So, and that's really just highlighting in a very simple way the difference between what might happen in a negotiation that is adversarial, where it's you win or you lose or we split it down the middle, as opposed to the more creative options that may be available through using other techniques in negotiation, such as principled negotiation. So if you haven't seen 12 Angry Men, I'd encourage you to do so. It's a good Friday night movie if you're into Friday night movies, or Sunday night, but it's a really good movie. The star of the show, of course, is Juror Number 8. This is a movie that has been classified as having great cultural significance. Jamie has seen it. Karen saw it last night. Both enjoyed it. That's good. Thank you. Hopefully that's good encouragement for others who haven't seen it to watch it. I really enjoyed it. And it is clear from that movie that people do argue from their positions rather than their interests. They shouldn't, but they do. That's in human nature. So it's a good way to demonstrate the benefits of principled negotiations. You'll also need to think about some tips on breaking deadlocks in negotiation, and just be aware that sometimes people do want to. So the point of the orange story is if the mediator digs deeper into and encourages the interests of the parties as opposed to their position, that would be better. Yes, because sometimes there's just a lack of communication between the parties, and all they want is, I want the orange and not her. That's what the usual sort of starting point where people are promoting their position rather than their interest.
So I was just going to say, like a real life example of that is I work in the disability sector for the National Disability Insurance Scheme. So a lot of the time we have a lot of participants saying, I want this support, I want this support. But you go really dig deeper and they want that support in the home to help them clean so they can go out in the community more, so they can get to their jobs and stuff like that. So that's the real purpose of what they want rather than
exactly.
Yeah.
That is a great illustration. So you're really looking at their interests and not just their position. So thank you. Karen, do you wish to add something as well about the Florian?
Yeah, I downloaded that today, having watched the movie last night, and just found it a really good read for all the different techniques that he used on the different jurors, and without really forcing it, got everybody to change their minds.
Exactly. And that's a key point to it, because juror number 8 didn't take away ownership. Some of the other people in the movie wanted to take away ownership of the decision making from the jurors, but juror number 8 didn't. So that's a really good observation. Thank you, Karen. Jamie, do you want to share something?
Yeah, I'm trying not to unmute my microphone because my kids are running amok in the background, so I was trying to keep the noise down. I attended a mediation session last night, or yesterday afternoon. Sat in one. It was a personal injury dispute. And the mediator, during her opening statement, mentioned something along the lines of, during this stage where you're making your offers, both parties are making offers, if the offers are unreasonable and unrealistic, then she will intervene. And I thought that sounded a little bit more like conciliating, because she's getting involved a little too much rather than mediating. I wasn't sure if that was the case.
Well, I think there are different models for mediators. Lawyers like to get involved. I actually like that approach that was used by the mediator. But it is very close to conciliation. And you will find that a lot of mediations are run in that way. So it is to some degree a matter of resolving the extent to which the mediator will become involved during the intake process. That's certainly what I try to do as well. But it's an interesting observation. It's not wrong, but you're right. It's getting close to the conciliation model.
Thanks, John. Cheers.
Well done for being able to sit in on one. That was excellent, Jamie. All right. So there are some issues in terms of breaking deadlocks. You'll need to have some techniques in your toolbox ready to go. And I think what I'm trying to do is encourage you to be prepared for these things that occur during the mediation session, where you've only got a matter of potentially seconds to do something about it. Otherwise, that opportunity is lost. So be aware of these issues, practice them, think about how you would react in different circumstances so that you're ready to act appropriately when we get to the mediation session proper. Thank you for your patience. I think that's probably all we should do tonight. Before I sign off, are there any questions, comments? Thank you for your participation. Thank you for listening carefully. All right, I'll end the meeting now. Thank you and all the best. We'll see you next week.